Hi, Reverend Tony Suarez, and I'm here to discuss our book. Now we're into chapter 4. Now, from chapter 4 on, it's really a discussion of individual issues. And you really have to get into the book in order to be able to understand it. I'm going to review the cases with you and some of the basic principles about those particular areas of the law, but you need to read it and be able to absorb it so you can really understand. I start in chapter 4 with the discussion of the right to abortion. The right to abortion has been very controversial. Of course, now we've had a decision which seems to have reversed the right of abortion, but it's because we misunderstand the actual premise, the understanding of the underlying thinking and logic of the court. So let's start with what is this right? Roe versus Wade, which everybody thought they understood. And it comes from the fact of what's called an implied right. Well, there is no right to abortion in the Constitution. So there's nowhere in there are you going to find that there's a right to an abortion. What it is an implied right of privacy. And that implied right comes from things like when the Fourth Amendment, when you have the Fifth Amendment, when you have the right to remain silent, and the Sixth Amendment, when you cannot search your property, the government cannot put some soldiers inside your home. So there are certain constitutional established rights that are enumerated, and they're called enumerated rights in the Constitution, but also then becomes implied rights. So if you have the right to remain silent and you have the right to your private speech, there seems to be then an implied right of privacy. So the police cannot enter your home without a warrant. Well, what does that mean? It means that you have an implied right of privacy. From that implied right of privacy comes the concept that the woman has control of her body because it's her private body, and therefore she has the right to decide when or how she can use her body. And so that's, and there are people who will say, it's my body until whatever point. That means 9 months, 7 months, 6 months, 4 months. So in the case of Roe v. Wade, the court was trying to balance this thing out as, wait a minute, what about the right of the fetus? Does the fetus have a right? And does the government have a right to interfere to protect the right of the fetus if the fetus is a person? So now, if the fetus is a person, then they have rights, and the government would seem to have the right to interfere to protect that right, and that clashes with the woman's right to privacy. What the court tried to do is, and literally the Solomon thought was cut the bait, right? The Solomonic evidence was, okay, well listen, look at the evidence from science, and tells it that the first 3 months, the first trimester, the baby is just not a viable life, therefore not entitled to protection from the state. Somewhere in the middle of the second trimester, that child has a possibility of having viable life outside the womb, and therefore there could be some restrictions that the government can do to try to protect that life, as opposed to a woman's absolute right to terminate at any point. But in the third trimester, because at that point the child has more likelihood of viability, then the courts have said, well, at that point, that child at that age has more rights to be protected by the state than does a child that's in the first trimester or a fetus in the first trimester. So based on that is how the court decided, in a sort of the wisdom of Solomon, to how to divide that right. And that was what people considered what's called a precedent, a decision which would bind on courts below. Then Dobbs came, and Dobbs came around, which basically changed the ability of how the states can deal with the issue of abortion. But the Dobbs decision did not actually say that there's no right to privacy. It didn't say that, okay? It just said, it looked at it differently. The government has a right to check procedures, of how procedures are. So does the government have the right to license doctors? Does the government have the right to license hospitals? Does the government have a right to license practices and procedures, and how can they do oral surgery? If you do oral surgery, what kind of anesthetics can be used, what kind of anesthetics cannot be used, what medicines can be used, cannot be used? Well, if you agree that the government does have some rights in how they control the medical part of it, then if you look at it that way, then you can say a state government can say, we will not allow an abortion at a certain point, because they're not dealing with the woman's individual rights, they're dealing with the procedure that they're allowed to put into place. And there comes the state's rights in order to to control the procedures, the medical procedures in their state, which no one denies exist, with the clash of the woman's individual rights to have an abortion and control her body under any circumstances. How that plays, what is more important when you have that clash of rights, is discussed in this chapter in detail, so you can understand what procedure was being used by the courts to untangle this very difficult question of the state's rights on their procedure and individual woman's rights of her privacy. So Dobbs did not do away with the right to privacy. It simply meant it allowed the states to regulate the procedure by which an abortion is handled. For more detail, you go to our book and you can really do some analysis then.